Hello everyone. What we've learned this summer with buyers trying to exit transactions is that it's extremely important that you understand basic contract principles so that when a contract is put together in the first place, there are no opportunities for somebody to cancel it later. So let's start. What constitutes an offer? Just because a buyer signs an offer, it's not an offer until it's communicated to the other side. And communication has to be by fax, email, or personal delivery. So if you are on your way over to the listing salesperson with an offer, and the buyer changes their mind and calls you and says, don't present, you do not have to present that offer. Now, to accept that offer, it's not enough that the seller has to accept it. Communication of that acceptance has to go back to the buyer or to the buyer salesperson. And that communication has to be by either fax, email, or personal delivery. And if it's not done in time before the irrevocable, you do not have a proper acceptance. So remember, it's not just the acceptance, but it has to be sent back in time. And this is why we sign the acknowledgement. The reason for the acknowledgement is for the last person, in this case the buyer, to say, yes, the acceptance was communicated to me in time. Next, the seal. Why do we sign the contract under seal? Really, a real estate contract doesn't need a seal. The buyer's giving money, the seller is giving the property. The reason for the seal is because the buyer makes two promises when they sign that offer. Number one, I want to buy your house. Number two, this offer is irrevocable for 24 hours. No one paid the buyer to make that offer irrevocable for 24 hours. That's why if the offer was not done under seal, the buyer could just cancel the offer at any time before acceptance. So the way you explain the seal to a buyer or seller is simple. You can't change your mind before the irrevocable. So these things are serious. An offer is serious. Once you put it in and it's communicated, you can't change your mind. Related to this is the time is of the essence clause. What that means is every time period matters. So, as an example, the deposit is supposed to be paid within 24 hours. If it's paid late, the seller can cancel the deal. Conditions have deadlines. If you miss the waiver deadline, the contract can be voided. However, as you can see, it's not always that simple. Let's say the seller, for example, accepted the contract, passed the irrevocable, sent it back, buyer acknowledged it, and everybody proceeded to try to close the deal without focusing on this. Then, 3 months later, on the day before closing, the market changes, and the buyer lawyer says, oh, the seller accepted this too late, there's no deal. Not true. You see, even though it could have been terminated at the time, the fact that both sides were treating this as though it was a deal and were preparing for closing, it may now be too late for someone to change their mind. However, as you can see, there'll be lawyers on both sides, and this is going to end up in court. So the moral of the story is get your contract signed, initial, communicated in time, pay the deposit in time, send your waivers in time so you make sure your contract is bulletproof as much as possible and nobody tries to attack it later. If you have any questions about how to sign, enter, or what happens when you break a real estate agreement, please do not hesitate to call me at mark@realestateLawyers.ca or toll free at 1-888-876-5529. With my partners at realestateLawyers.ca LLP, we are delighted to represent you or your clients in any transaction. Thank you very much.